Good morning, Council. This appeal is Appeal Number 29, matter of National Fuel Gas Supply Corporation versus Scheuckler. Mr. Joyce?
Good morning, Chief Judge DiFiore. May it please the court. I'm Eamon Joyce on behalf of National Fuel. May I reserve 3 minutes for rebuttal?
You may, sir.
Thank you. While a FERC-approved pipeline project involves many moving pieces in a complex regulatory scheme, the questions before you are straightforward, and they have straightforward answers. This case is about statutory construction. The appellate division repeatedly erred in that task. One, it badly misinterpreted what EDPL 206A requires, which was no more than a certificate of public convenience and necessity from a federal commission,
Counselor, if we agree with you on that, do we need to address any of the other issues that have been raised in our...
No, Your Honor, you don't. I frankly think it is important to get to the second issue because that one has the broader repercussions. The majority's disregard of what 206A textually required, excuse me, if, I think I did that answer backward. No, you don't need to get to the effect of the waiver order if you find that 206A only requires a certificate of public convenience and necessity, which is what the statute says. We're done. If you were only to get to the waiver order, I think that would be a mistake because the 206A ruling about a certificate of public convenience and necessity is the more important one for the lower courts.
Counsel, to be clear, just so I understand your rule is once that certificate is issued, it regardless of whatever contingencies are contained in the certificate, that satisfies the state statute. Is that your position?
Largely, yes, Judge Rivera.
Where does the rule apply if you're saying largely?
Let me note in a second one possible exception.
Okay.
Any contingency on construction, yes, will satisfy the statute because all 206A requires is a certificate of public convenience and necessity. Congress gave FERC expressly the power in 717R sub E, the power to condition its certificates. Now, there is one thing that FERC can do that it didn't do here, and it's important. Sometimes FERC conditions not construction, but conditions the exercise of eminent domain. It's powerful that FERC didn't do so here, and it didn't do so here for good reason. It's because...
But counsel, if I can interrupt you, but
sure.
Let's just stay for one moment with the denial of the permit. Right? Let's just say, I understand you have a position on that denial. Let's just say for one moment, stay with me, that there's a denial of the permit. Why would the court permit eminent domain to move forward when you cannot proceed with the construction?
So, Judge Rivera, I think it's important to understand what the majority misapprehended about denial of a WQC, which I think is bound up in Your Honor's question. A WQC permit, in fact, has nothing to do with construction. All a WQC permit does is it authorizes a discharge. The Delaware Riverkeeper opinion from the DC Circuit makes that clear.
Yeah, but that may affect, and so, if I can interrupt you again, that may affect, indeed, the construction, which may affect what part and how much of the land National Fuel Gas is trying to obtain through the eminent domain process, through the condemnation process.
The denial of a WQC does not prevent any part of the construction, any part of the project from going forward. Indeed, even while the WQC was denied, that is before FERC found it waived, the project continued to go forward. My
Counselor-
clients were
Counselor,
under
could-
FERC obligations to continue submitting status reports, which they did, and the project continued on.
Counselor, could the
Sure.
landowners have sought and possibly obtained a stay from FERC of its certificate under these circumstances?
Absolutely. It's the only place to obtain a stay, right? The CPLR provisions that we've cited and the USC provisions that we've cited make FERC orders immediately effective unless they are stayed. And those orders sometimes are stayed, and they can be stayed in different ways. FERC can stay the certificate pending completion of certain conditions. FERC can stay, as I noted before, the exercise of eminent domain. But
Can I interrupt you a second just to go? Excuse me.
And in fact, the only
Counselor,
stay that
Counselor,
was sought by DEC and the Sierra Club, and it was denied.
Mr.
And now
Joyce,
here we are
Mr.
at the Second
Joyce.
Circuit, where DEC and Sierra Club didn't even seek a stay. That is, we are fully going forward
It's all right, just let him
on
finish.
this pipeline project, and FERC recognizes it. It's defending its waiver order
Mr.
currently
Joyce.
before the Second Circuit. If
Mr.
anyone would
Joyce.
have an interest in saying this pipeline project doesn't exist, none of this is ripe, don't bother us, it's FERC. But yet they're mid-briefing, they filed their oral argument statement in the Second Circuit yesterday, as did I. We're full steam ahead.
Mr. Joyce. Mr. Joyce, Judge Fahey.
Judge Fahey, thank
Yes.
you.
Slow down. You have to listen for our questions. When you get rolling like that, you can't hear us. This applies to both counselors. And we're trying not to interrupt you. We want to let you make your argument. And then, so be careful, all right? Listen for our questions when you're talking.
I'm sorry, Judge Fahey, I didn't hear you.
Yeah, that's all right. Nobody else did either. Don't worry about it. But listen, my question to you is, the way I understand your argument is that that National Fuel Gas doesn't need a water quality certificate because it only authorizes construction and not the eminent domain proceedings. Is that an accurate statement of your argument?
No, Your Honor. So,
All
and
right,
maybe I
briefly,
misapprehended your
slow
question.
down.
National Fuel no longer needs a WQC because FERC has found the WQC requirement waived by the DEC.
All right,
My-
let me stop you. What's the record that the appellate division then had in front of it? I'm going to assume that they before the FERC ruling, you needed a WQC to go forward. And the way I understood the record in front of the appellate division at the time the majority made their decision was their decision was made after, the waiver order came after Supreme Court's submissions, after the appellate division record had closed, and after this case was argued. I think, and then this FERC waiver order came down after that happened. And you're saying that the majority should have then considered that order. Is that correct?
That's correct.
All
Let me
right,
take on a
so
couple.
let me stop you.
couple
No,
earlier
that's
points
all I want to
found
know.
open.
So my point is that after the entire record was closed, you're saying that they should have gone back and changed it rather than go forward with the case. Is that?
I don't think that's accurate, Your Honor.
All right, then tell me why
At
not.
oral argument before the Fourth Department expressly asked to be updated on any issuance of a waiver order. Council did that and sent that waiver order. And so at the time the appeal was decided, the law as it stood before the Fourth Department was there was a waiver order in effect.
Can I
The Fourth
ask you?
Department didn't actually dispute that. The Fourth Department said it wasn't judicially noticeable. But as we point out, CPLR 4511 requires mandatory judicial notice.
No,
And this
but we're
court
talking,
has
stop.
repeatedly
We're talking,
held
stop.
that-
Counselor,
Sure.
Counselor, what we're talking about here is permissive notice under 4511B, and it says they may or may not consider it. They made a decision, they went forward. And I don't think
That's
this is,
incorrect, Your
excuse
Honor.
me.
It's not permissive notice here.
Well,
40
we might just,
4511A, common law of the United States is mandatory, and 4511B is mandatory on request where there's an ordinance of an agency of the
I'm
United
not
States.
sure I agree with you, Counselor.
Which this is. So
Counselor?
it's doubly mandatory, Your Honor.
Counselor, you got to slow down, all right, just so I can get my point in, okay? I don't think you're correct about that. I don't think that this constitutes a mandatory requirement of notice. Leaving that aside, one way or the other, it was clear when the majority made their decision here that this decision had not been made, and that the writing came out then afterwards, after the decision had been made. That seems to have been, well, I don't know if you agree with me, but my experience at the appellate division seems that's the sequence of events that actually took place here.
Well, it's incorrect, Your Honor. That came out after the decision had been made. It came out after oral argument, but prior to decision, which is why both the Fourth Department majority and the dissent referred to it. And then the Fourth Department majority's reasoning for rejecting it was that it couldn't be judicially noticed.
But Counselor, your position.
I'm sorry, Your Honor.
Isn't your position that helps your position, but that's not necessary, because even were there no waiver decision here at that point, it did not preclude the eminent domain from going forward.
That's exactly right, Justice Stein. And look, we had always argued below that waiver or the WQC was a red herring. Indeed, as this case found itself before the Fourth Department, it was functionally no different than the Eagle Creek case in which Your Honor sat on the Third Department.
Mr. Joyce, could I just ask,
Sure.
I want to get your understanding of, suppose, just hypothetically, DEC had denied the water quality permit timely, right? Does
Correct.
that prevent National Fuel from doing anything? What effect does that have?
It's a great question. It prevents it from doing two things. One, it prevents them from discharging. That's all the 401 does. It says you cannot discharge into the navigable waters of the United States. So that's the primary thing it did here. Two, because FERC made the other federal authorizations, including a WQC, a condition on construction, it prevented National Fuel from constructing. But National Fuel had to do any number of other things. Those are, I think, largely detailed in reply brief 18, note 2. We had to submit site surveys of the lands that would be affected by this project, including respondents' land, and any number of other pre-construction conditions.
But ultimately, Counselor, ultimately, you cannot go forward on the project without the WQC. Is that correct?
No, Your Honor, we cannot construct the
All right.
project.
Well, if you
absent
can't,
the
let's
WQC.
just deal with the logic of that response. If you can't construct, then you can't do the project. There's no point in going forward. Yes, you could acquire, you're saying, but we couldn't build. Is that what you're saying to us?
So,
What would be the point of acquiring if you couldn't build?
because the question of whether we could build was very much open. You know, respondent tries to turn this into a failed condition, but it wasn't. Even if it had been denied and there was no waiver, we had a Second Circuit appeal, which overturned the WQC decision. DEC itself said we could reapply. Look, this case doesn't look, as we pointed out in our response to the amicus brief, any different from Goldstein or Cower. When eminent domain was authorized, Atlantic Yards couldn't go in and build until it had DOB approvals. When in Cower, Columbia got the right of eminent domain, it couldn't suddenly put up a tower. It had to go through a host of approvals, and all of those lie downstream. And the legislature has always known about that. And yet the legislature makes 206A hinge on a certificate of public convenience and necessity, not one that's that has conditions, not one that's exhausted judicial review. Under 204 and 206, the legislature has never said eminent domain only occurs where a project is shovel ready, and for good reason, because eminent domain, as here, as FERC pointed out here, and as FERC has pointed out in numerous other cases, eminent domain is often antecedent to satisfying the conditions of construction.
Thank you, Mr. Joyce.
Thank you, Your Honors.
Counsel?
Thank you, Your Honors. May it please the court, I would like to reserve 3 minutes for rebuttal.
Counsel, there's no rebuttal, but please go forward with your argument.
Thank you. The Scheucklers have never stopped National Fuel from coming on their land to survey. Let's start there. We concede that National Fuel's FERC certificate is valid. However, a FERC certificate can be both valid and ineffective, and that's what we have here. Its validity imposes conditions, and if important conditions fail, the FERC certificate is no longer effective.
But Counselor, it seems to me that there are
Your
a
Honor.
lot of procedures that the landowner could follow and could undertake to put a hold on things if they think that the circumstances don't warrant them going forward with eminent domain. But it seems to me as well that those procedures don't include having a state court decide what position the construction of this structure is in, that it is up to FERC and the federal courts to make those decisions, that they could seek a stay, that they could appeal certain things. But what you're suggesting is that a state court has the power under the eminent domain procedure law, as it's written, to as things proceed and as things change and as these things go forward with all their complexities, to make that determination at a single moment in time, so that you'd be having you'd be having National Fuel, for example, coming back and forth and back and forth and back and forth, depending upon what was happening that day and what court and so on and so forth. So that, I guess, that's a long-winded question, but really it is where does it give a state court the authority to determine whether the FERC certificate is, I can't remember exactly what the term was used, but whether it was effective? That's my question.
Incipient. Well, it's certainly not effective if a water quality certification has been denied by the state. The state has blocked the project.
But the water quality certification was subject to reapplication, that the denial of it was subject to appeals and all sorts of things. So my understanding is that there are all kinds of conditions that are in flux all the time on these things, and that some of them, in fact, can't be met until there's eminent domain. So it becomes a catch-22, and this thing can never be built.
No, that's what it looks like, perhaps, but it's not that case when a water quality certification has been denied. That's a special circumstance, a special condition.
Where does it
It's
say
almost
that
jurisdictional.
Where does it say that in the eminent domain procedure law in 206A? Where does it say that?
Well, it doesn't say that, Your Honor. But the kind of certificate that National Fuel has is not the kind of certificate I believe the EDPL contemplates. EDPL 206A in particular shouldn't be read to allow National Fuel to avoid any demonstration that its project would or is even likely to satisfy the 204B factors under New York's public purpose test. Merely presenting a conditional FERC certificate and asking a court to deem all the conditions met is not appropriate, where the record indicates an important condition has failed. In fact, a jurisdictional condition, the Clean Water Act, preempts the Natural Gas Act. That's what the Fourth Department found, and that's what the Clean Water Act says. It says no license, no federal license shall issue without the water quality certification.
Just to clarify,
So a landowner ought not to be burdened while a condemnee litigates the blocking of its project. A condemnee can refile with proof of a public project after it wins its dispute. We're not parties. The Scheucklers are not a party to the
Counselor.
Second Circuit or the DC Circuit litigation. We have no control over that. In
Counselor.
the meantime, it
Counselor.
cannot be shown or it cannot be known whether National Fuel will be permitted to move forward with development.
Counselor.
Your Honor.
Counselor, the Clean Water Act.
Yes.
It's a federal act, right?
That's correct.
All right. And the requirement for a water quality certificate that the state must issue is a product of federal law, correct?
That's correct.
All right. So in that circumstance then, in the circumstance we have here, this wasn't a matter, I think Judge Stein is correct as far as the ruling goes, certainly she is, but the state's court's ruling was in effect based upon its understanding of the application of the requirements under federal law. Is that a fair analysis? Is that correct?
No, I disagree, Your Honor. I
Okay, tell
disagree.
me
I think the appellate division ruled under EDPL and said National Fuel should not be exempt from the obligation to demonstrate it as a public project. Since it has no project, it cannot have a public project.
I see. So in the absence of any project, they don't have any right to eminent domain procedure law, is what you're saying.
That's right. And this is a fairly unique. This is not going to happen every day because there aren't conditions which, when they fail, have this result.
Why?
As you said,
Can I ask you a
as others
question?
have said,
Can I ask
there are
you a
many
question?
conditions.
Counselor, can I just go off this point for 1 second? Other judges may have questions on it, but can we turn directly to the certificate itself? I had understood that both parties had agreed to an extension of the water quality certificate's time period, DEC's time period for approval. Is that correct? It's required to be approved within a year, but both parties, you and National Bluegrass, had agreed to an extension. Is that right? Counselor.
We're not a party to that. The parties to that did that. You're correct, but I just want to emphasize we're not a party to that. We had nothing to do with that.
I see. Okay. Thank you, Counselor.
Well, I want to emphasize the time frame here. You know, when the Scheucklers appeared in trial court, National Fuel's federal water quality certification had been denied, and it could not demonstrate it would ever obtain the certification. National Fuel still has no relief from New York's action blocking the pipeline project. It's been over 3 years since National Fuel filed its petition, and the company still has no light at the end of the tunnel. It does not hold the sort of license, permit, or similar approval contemplated by the EDPL. And I think this court should carve out a clear rule that when a essentially jurisdictional condition fails and the project is essentially blocked and there's no light at the end of the tunnel, it's unconstitutional to take people's land. If they want to work their dispute out in other courts and get over that obstacle, they can come back. That's what the Fourth Department said. Start all over.
So, Counsel,
take the land then.
Counsel, you keep describing the water quality issue as jurisdictional. The certificate has a number of conditions, things that are expressly described as conditions, and that's one of them. Why? I assume you don't think that everything that has the word condition is jurisdictional. Is that right so far?
That's right.
All right, so how do we distinguish? I mean, to me, these things don't look as if they're conditions precedent. Many of them clearly can't be conditions precedent because of the way that they're worded. So why is it, can you articulate why you say this is different from every other, or at least from some of the other things in the certificate that are identified as conditions?
Yes, this is different because the authority and the understanding, the meaning of the law is outside of this certificate. It's found in the Clean Water Act, which says without a water quality certification, you may not have a federal license.
Thank you, counsel. Mr. Joyce?
Thank you.
Yes, Your Honor. Sorry, I was struggling to find my mute button. I think I have 3 points in rebuttal. The concession that the certificate is valid is dispositive here. The claim that it's no longer effective is simply wrong. That's wrong because the statutes tell you that. 15 U.S.C. 717 R.C., 15 U.S.C. 3416A5, and 18 CFR 385.2007C1 all say that FERC orders are effective when issued unless stayed. Here, there was no stay.
Yeah.
Moreover,
Counsel, if I can
the
interrupt you,
precise-
excuse me, counsel, great. I'm
Yes.
glad you heard me. Good. You see my hand up. Okay.
I couldn't see your hand up, Judge Rivera, but I
that's
could hear
fine.
you. I'm sorry.
That counsel, but that's fine. All right, but whether it's effective or not, let's go with it's effective. The question is, what's it effective for? So as I understand the argument, it's that it can't be effective to allow you to seek to proceed under the statute for condemnation because you don't, let me finish, because you do not yet have a WQC. Now, it may be true that in the pending litigation over this issue, that indeed FERC's determination that New York has waived its opportunity under both state and federal law, the Clean Water Act, to issue or not issue that WQC has, they've waived their right to do that. You may succeed on that, but that is not the ruling that exists yet. So why is it that we can't take judicial notice of the fact that you've got all that pending federal legislation when you're arguing that the appellate division had to take judicial notice of the FERC decision?
So let me start with the first question you raised, which was, does the WQC prohibit the exercise of eminent domain? No, it doesn't. That's the issue that the D.C. Circuit addressed in Delaware Riverkeeper and has been addressed by FERC. The certificate is immediately effective for eminent domain purposes, even if a WQC condition on construction remains outstanding.
But counsel, if I could just interrupt you there. Counsel, if I can interrupt you there. But how could the project proceed? I get you could, I'll stand with your argument that nevertheless you can proceed to condemn the property, but then you don't get the WQC. So under the Clean Water Act, that's the end of the project.
Only if there's a discharge, Judge Rivera. If the project could be set up in a way where you don't discharge, and again, I'm taking for granted.
Counsel, I understand you keep arguing you might find another way to get permission. My hypothetical, my point is, if you never get that permission, you cannot proceed with the project. Isn't that what the Clean Water Act makes very clear?
The Clean Water Act makes clear you can't discharge without the certification. It doesn't have anything to do with construction. In fact,
Well, how can your project proceed without a discharge?
Because if we're not crossing federally navigable
Let's go to the
streams, we can
second
proceed.
question.
Judge Rivera, I think the easiest way to illustrate this is we had a WQC from Pennsylvania before we had a FERC certificate. We couldn't go out and construct. It's a condition on construction. It doesn't mean that the project goes forward or doesn't go forward. And then I think the answer to your second question is, if you take judicial notice, then you find yourself in the shoes of a case in which we have everything we need. There is no WQC. It doesn't exist.
I mean,
it's gone.
Mr. Joyce,
it's been waived.
Mr. Joyce, Mr. Joyce,
reaffirmed it on waiver,
Mr.
and now
Joyce?
DEC is challenging that on appeal before the Second Circuit.
Mr. Joyce, your point essentially is that in the worst case, you're wound up having paid for land that you've taken through eminent domain that you can't use.
That's correct. And I think that's similar to what happens under 204 and 206 and has for years. If Columbia can't get all its permits to build the project, the Development Corp authorized in CAR, those are the repercussions and the remedies. I'll say that National Fuel doesn't want to spend money for the sake of spending money. Its view is this project is going forward, and FERC views it the same way.
Thank you, Mr. Joyce.
Thank you, Your Honor.
Thank you, Your Honors.
rise. Hear ye. All persons having further business before this Court of Appeals held in for the State of New York may depart hence and appear here Tuesday afternoon at 12 o'clock, to which time the court now stands adjourned.